Welcome to the Lord Talk Legal Aid Initiative podcast. So today we'll be having a discussion with our very own constitutional law lecturer, Dr. O'Brien Kaaba. Thank you for coming, sir.
Thank you.
Today we'll be discussing the topic, what are the shortcomings and the weaknesses of the Zambian constitution? And if so, do we need a new constitution? Today we'll be discussing this with Kunda Mlenga. You can introduce yourself.
All right. So my name is Kunda Mlenga. I'm the Secretary for Legal Aid Initiative. And well, I'm super excited to be here and to have Dr. Kaaba on board. It's really a rare opportunity and privilege. And I hope that obviously we will learn a lot from him because we have very wonderful questions on board and we're willing to learn about the Constitution today.
Okay, so to start, you can introduce yourself.
Thanks very much. Thanks, Chimwemwe, and thanks, Kunda, for inviting me to this inaugural podcast. I'm truly honored and I appreciate the initiative. So as already indicated, my name is O'Brien Kaaba. I teach law at the University of Zambia, and I'm honored to have had you in my class. Thank you.
Okay, so we can we can go ahead with the discussion. So the first question to you, sir. Does the Zambian constitution show a true reflection of the separation of powers?
Yeah, thanks. That is an important question. We can say there's a way in which the constitution reflects the doctrine of separation of powers. That is, it has clearly demarcated territory in relation to the three organs of the state. So you have a clear judiciary, which is separate from the executive and legislature, and then you have two other organs, that is the executive and the legislature. So from that perspective, there's separation of power. But then the issue usually is as to whether the other entities are able to operate without the domineering effect of the executive. The issue arises because the executive has a monopoly of the use of force. The president is the commander-in-chief of the armed forces, and he's also in charge of the police. And the executive is also in charge of the state resources. So from that perspective, the executive naturally, across the world, the executive tends to dominate. But then the concern in our context is whether we have strong safeguards against an executive that decides to misbehave. And I think that is where separation of power arises in our specific context. And beyond that, it is the issue of what I would call horizontalization of the state, so that the executive is held accountable for how it uses power. And I think that is where we tend to struggle in the Zambian context. We have an executive that is so powerful and overrides in some instances the other two arms of government, and that has been the concern in all the previous constitution making processes. So we have been struggling to find the correct balance for the three arms of government to coexist harmoniously. Yes.
So the second question is, what is the effect of having many amendments to a country's constitution?
I think to start with, the main constitutional amendments and also constitutional review processes we had reflect the fact that we have not found balance in our constitutional order. So as a result, the country keeps on searching for that time when we'll say we have sort of arrived, at least in terms of the major issues in the constitution are settled, and then we just remain with clarifying language, or at least growing the constitution itself. So we, in my view, haven't reached that stage. So as a result, we continue having these amendments or constitution review commissions. that tells us that we are in this search, and the search continues. So one of the effects of having changes upon changes without a clear underlying framework which sends a sense of arrival is that you create a lot of ambiguity in the document, and you create a sense of uncertainty. So, for example, in relation to the 2016 Constitution Amendment, we have several areas of uncertainty, ambivalence. So what do you do, for example, where you have provisions that are contradictory? So between the provisions that were not amended and the new provisions. So if I may give one example, the definition of discrimination. So when you go to Article 266, there's a definition of discrimination. And when you go to the Bill of Rights in Article 23, the Bill of Rights gives you what it considers to be discriminatory conduct. But then the two are not consistent. And in one of the cases which came to the Constitutional Court, the court seemed to suggest that the definition in 266 is unconstitutional because it violated what is in the Bill of Rights, which was not amended. So that kind of uncertainty is the fruit of having so many changes, but when those changes at the same time do not answer the core constitutional challenge of what is the issue with the Constitution.
So, sir, on that note, so do you think the Constitution would need mere amendments or just a complete structural change, seeing that there's a lot of language, a language barrier, gaps in the Constitution? So do you think Zambia really needs small amendments or just a complete structural change to the whole Constitution?
Yeah, thanks. That's a very important question. In my humble view, I think we have not settled the constitutional problem as a country. We haven't decided which way to go and what systems of government we should put in place. I'll come a little bit to that. But to answer the question, I think we have a lot of foundational problems which we haven't dealt with as a country, which are legacy issues, historical issues. And as a result, we need to deal with those. And to deal with those, I think it is not enough to simply do superficial amendments. We need to go to the root of the Constitution itself, to determine the incentive structure and power map of the Constitution, and then redesign those things. So I have three things in mind. The issue, for example, of national cohesion, because of the way the state was created. It basically brought together many nationalities. So after independence, the question was, how do all these people live together as one? So Count and his friends did their part. But then, as you know, I think, and as you have seen now, I think there's a lot of ethnic polarization in the country that needs to be dealt with. It's a big constitutional issue. You cannot wish it away, and you cannot, it's something that is not going to evaporate until you take it head on in constitution making. You have the issue of law and order, which is still bedevils the country. During colonial rule, in order to manage the huge swaths of land and the people, the administration basically had to use sort of repressive laws like the Public Order Act, Societies Act, and the like. These have continued, and new ones have been added on, like the Cyber Security and Cyber Crimes Act. And then because of the administrative culture and judicial culture, then the Constitution has been interpreted in reverse to fit it into these repressive laws. So that tells you that we need a new beginning also to ensure that you recreate the state so that you get rid of those repressive laws and also get the Constitution to be interpreted in a forward-looking manner. But to do that, you need to write a new Constitution, but also put in place an implementation mechanism for that. So, for example, when Kenya wrote their 2010 Constitution, what they did was to put a 5-year program for constitutional implementation. whereby you write new laws, or at least you rewrite the laws so that they are aligned to the Constitution. You don't have to take the risk of the courts doing that for you, because as we have seen in our context, the courts have often played a negative role, especially in cases which are sensitive in relation to the exercise of power, and the executive has an interest. So the courts have generally allowed wide administrative discretion. And the final one is the issue of state legitimacy. So because of the way the state was established, basically, many people do not have a sense of loyalty to the state. So the state is seen as a resource from which people can derive benefits without giving much. And the consequence of that is you see widespread corruption, looting of public resources without any qualms. So that tells you that you need to reset the state, to infuse in a lot of high ethical standards in the Constitution. So without that, and if you simply look at issues of clarifying language, I think you miss the big problem about the constitutional problem in Zambia. And in my view, we need to attend to those. But in addition, if I may give one other problem we need to deal with as a country is to decide what kind of governance system we want. Is it presidential? Is it parliamentary? Do we need to combine this in a way that is healthy for the country? So at independence, what happened was when we got our independence, the countries that got independence from Britain before us in Africa, they were given the the Westminster Foundation, where you the Westminster model, where you have a titular president and an executive prime minister. So the prime minister was in charge of running government, and the president was largely ceremonial. But then there was conflict in the executive. The president wanted to do this, the prime minister would do this, and that led to a lot of instability in many countries. So by the time we got ours, the British tried to experiment, and we were at the first Anglophone country in Africa to get a presidential system. But then it wasn't a purely presidential system in the American sense. Ours was sort of a hybrid, because they maintained the core elements of a parliamentary system, where part of the executive, except the president, were based in that house. So ministers were drawn, for example, from that house. But then the president had his own mandate. So the implication of that is that the president then could not be held accountable by the legislature, because he didn't get the mandate from the legislature. So it wasn't a parliamentary system anymore. And therefore, the controls which were in the British system of having the president answerable, or the prime minister answerable to the legislature, were no longer there. And then you have now created a president who effectively is imperial, because there are no effective controls over the presidential system version we got. Yes.
So from the time of independence, we have so far had 4 constitutions. So would we say from these amendments, do they reflect the needs of the people, or we can simply say the constitution has been changed to promote a particular political agenda?
I think it's a combination of the two. So starting even from the process, there have been submissions by the people in terms of how they wanted the constitution adopted, and also in terms of substance. So some elements of, for example, on substance, like getting rid of deputy ministers, putting the election date in the constitution, those mirror the views of the people. But at the same time, other proposals by the people were rejected by politicians, like ministers should be from outside parliament and kind of stuff. So what that tells you is that although in some cases there have been relatively positive changes made, the provisions that pose a threat to those in power, or those that are perceived to have impact on short-term political interests of those in power at the time of constitution making, less likely to find favor. So that has been our story in constitution making, I think, the past years since independence. So those in office tend to go for short-term political interests at the expense of long-term constitutional interests of the country.
Well, so from that we see that there's some instability that is created, which is, well, quite understood, because we kind of deviate from seeing or changing the constitution with the intention of serving the people, but instead we would now promote political agendas, which is quite on a sad note. And, well, we hope such issues are addressed. So our next question is, what was the mode that was used to adopt the current constitution? And in your view, do you think it's the perfect mode?
Yeah, so unfortunately in constitution making, I think the word adopting the constitution is not as straightforward as it is made to sound on social media. So what exactly is meant by adopt? So yeah, so it really depends on the context. But often the word is used to indicate who makes the determination of what text should be put to the final process of approving the constitution. So if that is the case, in our context in Zambia, this role has usually been played by the executive and the legislature, in the sense that constitutional review commissions can write whatever they want, but then these are simply recommendations. So the person who ultimately determines what goes out to the final process has usually been the executive and the legislature. So this is, for example, distinguishable from the process that led to the 2010 constitution making in Kenya, where they had a clearly staggered process, and the enabling law established a clear mechanism and allocated functions to organs that manage the process. So Parliament was assigned a specific role, the people were assigned a specific role. The committee of experts which drafted the document had a specific role, and as a result, it was relatively easy to move the process, and each one knew, and then the process was protected by law, and therefore no one could exceed their powers, although there were attempts, but the design of the process was carefully balanced to ensure that ultimately the process succeeded. I think this is what we haven't done in our context in Zambia. I think we leave everything in the hands of the politicians, and I think this is where we have to draw a lesson, that if we have another opportunity at constitution making in future, we need to attend to the design of the process, because if the design is defective, the outcome is very unlikely to reflect the interests of the people.
Wow, beautiful response.
Yeah.
Well, I wasn't expecting that, because we've had a number of discussions as to what are the negatives in the current constitution, and what comes out is simply the net effect of everything, the end results, as opposed to the process of actually making the constitution. And that's a very fair response. Thank you. So what is the state of human rights and their protection in relation to the current constitution, if at all they are protected?
Mm-hmm. Okay, thanks. So we have a Bill of Rights in the constitution, which is fairly decent. The only major shortcoming is that it is basically a creature of the time it was written. So its language, its style, and its content is a reflection of the time when it was written. So that tells you that rights which were recognized much later are not reflected in the constitution. So socio-economic rights, issues to do with certain group rights, like rights of women, children's rights, and kind of stuff are not mirrored in the constitution. But that said, I think there have been a few attempts at progressive interpretation of the constitution. So in 2019, the Supreme Court in the Mwanza case enforced aspects of socio-economic rights to the extent that they were connected to the right to life. So that creates a bit of space for one to argue that other socio-economic rights could be recognized provided they are linked to rights that exist in the Constitution. But then that also should be, I think, taken a bit cautiously, because I think there have been 2 recent cases that came to the Constitution, to the Supreme Court, where the Supreme Court actually went in my view, the wrong direction. So one had to do with the driving rights for deaf people, and the other one was the legal capacity of people with mental health issues. And in both cases, I think decisions of the Supreme Court were wrong, and they are not reflective of the current trends in human rights. And those are areas of concern, in my view. And that tells us that then in conceptualizing human rights, we shouldn't just leave everything to the interpretation of the courts. It basically tells us that we need to rethink the way the human rights are currently captured in our Bill of Rights. So we might wish to expand the Bill of Rights to include socio-economic rights and group rights, and all the new issues and developments around human rights.
Right, thank you so much. So what I get from this is our current constitution only protects civil and political rights, yes, adequately covered. So they simply don't have a place for, the Constitution doesn't have a place for economic, social, and cultural rights. But what the court has done, the judiciary has opted to include these rights through their interpretation, right? But then I think that's not quite safe to leave the interpretation of these rights to the judiciary, because I mean, no rights should be greater than the other. And for all the rights to be enjoyed, they need to be enjoyed at par. They need to be enjoyed at par in some sense, because you cannot enjoy social and economical rights alone without enjoying the civil and political rights. So do you think that calling for a constitutional amendment right now to include economic, social, and cultural rights is a safe thing, or is a safe move for Zambia?
Yeah, so in constitution making, I think timing matters. Judging from news sources and social media, I think you get a sense that political parties and other stakeholders have started looking towards the next general election. And as a result, then the political mood is going to be polarized around partisan politics. So that in itself tells you that it might not be the right time to launch into a major constitution-making process, because whatever you do is likely to be interpreted around partisan political issues. And if that is the case, then it would be the wrong time to think of working around the Bill of Rights and the rest of the constitutional issues. But then at the same time, I think beyond the Bill of Rights, we have other constitutional issues that appear urgent and need to be attended to. So I'm not sure how those could be dealt with. So, for example, there are clauses to do with the consequences of a candidate withdrawing from an election having been duly nominated. So there's a recent interpretation by the Constitutional Court, but then that seems to only attach to independent candidates. So if someone was sponsored by a political party, it would suggest that the election would still need to be cancelled and a new process commenced. So in a general election, that could spin the country into total chaos, and that, in my view, needs to be attended to before the next general election. So it's either you get a correct interpretation from the courts, or you go through the process of amending the Constitution to cure that defect. Yes.
Wonderful.
Okay. Seeing as we're already 3 years down the line, this current government, do you feel that the current government is making moves into making amendments towards this constitution?
I recently haven't heard any position on which direction the government wants to go. But a few years back, the Minister of Justice had written, I think in 2022 in March, Minister of Justice wrote to civil society organizations to make proposals on the design of the constitution making process. And then the process went quiet. And then In 2023, I think there was an announcement that the government will first deal with non-contentious issues and then work on major reforms after the election. But that has also gone quiet. So currently, we effectively don't know which direction the government would wish to take the country in the area of constitutional reform.
Okay. And on another note, so with the Bill of Rights, seeing is that for us to have an actual amendment under Article 79, the Constitution needs almost 50% of people who are entitled to be registered as voters, meaning that people who are actually entitled to be registered voters, meaning that isn't that a bit vague if you read Article 79? Isn't it a bit vague or unrealistic when you put it in the sense that you need 50% of people who are entitled to be voters, not actual registered voters?
Yeah, I think the concern around the provision is that the threshold has been set too high. The standard in many countries is to take into account the people who take the initiative to register as voters, and those are the people who have to take into account in determining whether the election for referendum is won or lost. So the current law requires us to take into account even those who are not registered. So provided you have reached the appropriate age and you are a citizen, then you qualify to vote in the referendum. So basically, the threshold looks a bit unrealistic. And as you saw in 2016, I think the process had to rely on estimates of these people are and what number of people who are eligible are from the Central Statistical Agency. So that creates a bit of uncertainty because it's just an estimate. So for registered voters, at least you know with certainty because you have a voters register. But for eligible voters, you don't know because you are relying on an estimate because there's no way of ensuring that the referendum exactly coincides with the census. So because that might be difficult to tie the two processes together, you have to rely on guessing the figure of such people, and that's a little bit dangerous because you really don't know the actual number is.
So do you see this provision as a good safeguard, or is it a bit too rigid for us, seeing that we need to add social and economic, social and cultural rights?
Yeah, I think it has to. I think it has to be understood in context because if you look at our constitutional history, in 1969, government forced a referendum to get rid of any referendum to change the constitution. So that basically exposed the constitution to be manipulated by political interests. So when in 1990-91 there was a process to bring back multi-party democracy and to change the constitution, people were apprehensive, and then we swung to an extreme end. So it was sort of an overkill to lock out potential abuse of the tool for constitutional reform. And that is the context I think 79 should be taken into account. So it was seen as a process of safeguarding the constitution. But at the same time, I think not all constitutional reforms are negative. So, yeah, I think that we'll continue to grapple with that issue. My personal view is that Article 79 deals with amending the Constitution as it is. It does not deal with the issue of writing a new constitution. So writing a new constitution is a reserve of the people. It is something which is in the sovereign power of the people and is not limited by existing provisions in the constitution. So it really depends on how you frame the question. So if the question is for reforming the constitution as it is, then you have to comply with 79. But if the question is about writing a brand new constitution, then you face a completely different context. And in my humble view, Article 79 does not apply.
All right, thank you so much. So indeed, it has been an academic environment, and I've learned a number of things. I hope you have as well, Chimwemwe. Yes, so some of the negative effects or some of the shortcomings of our constitution would be ranging from the fact that it does not clearly state separation of powers. And, well, when we have members of the executive sitting in the legislative wing of government, what do you expect? And, well, the mode of appointing people in public office, that's some of the things that we should speak to. And except from that, well, what do you think are some of the best, what do you think are some of the benefits of having the current constitution?
The current constitution, like in theory, like it establishes the three arms of government, therefore bringing about separation of power. But as you pointed out, the shortcomings of the constitution, it being that we have members of parliament sitting in the legislative wing, that's also a negative part. Like we have separation of power. In practice, we have it laid down in the constitution, but we are unable to actually see it. But when you go ahead and see that members of parliament are actually in the legislative wing, and we have the executive having the power to appoint people in public office. So that's also seen as a disadvantage and an advantage again.
Right. Thank you so much, Imwemwe. So for me, Kunda Mlenga, I think we're coming now to the end of this program. It was really nice to have you on board.
Thank you.
Thank you so much.
Thanks for inviting me.
Okay, thank you.
Thank you.
Thank you so much for watching.